Hi friends, this is CS Rajesh. In this series of videos on drafting, pleading and appearances, let us look at how to draft mortgage deed. If you have not yet subscribed to our channel, kindly subscribe to our channel, and if you like the video, kindly press the like button and also share it with your friends. Now, what is a mortgage? Now, all of us would have studied what is a mortgage and what are the different kinds of mortgage and in Transfer of Property Act. Now, what is a mortgage? In simple terms, it is you are creating an encumbrance on the immovable property of the company to take a loan. So, in simple terms, that is mortgage. That is, you are creating a security on the immovable property of the company, saying, immovable property, saying that if at all I do not repay the loan, this property is there as a security for you. So, that is a mortgage deed. Of course, there are 6 kinds of mortgage which you would have studied in Transfer of Property Act. It could be a simple mortgage, or else it could be an English mortgage, usufructuary mortgage, or else a mortgage by deposit of title deeds, or else it could be a combination of any of these things. Of course, you have different rules and regulations for each of these mortgage, like where you take the personal liability, where you do not take personal liability. So, it could be combination of any of these things. But basically, what is mortgage? Mortgage is nothing but it is where you are creating an encumbrance, or else you are creating a charge, or you are keeping the immovable property as a security for the repayment of a loan. That we call it as a mortgage. And if it happens to be a movable property, then we don't use the term mortgage, we use the term pledge. Pledge is used for a movable property and mortgage is used with respect to the immovable property, of course, which is very clearly defined under the Transfer of Property Act of 1882. Now, how to draft a mortgage? Now, we have already seen how to draft a lease deed. The same rules we will have to apply as to how to draft a mortgage deed. Now, what is the first thing? First, we give the heading of the document. The document says that it happens to be a mortgage deed, or else a deed of mortgage. Then what is the next one? There you mention who are the parties, what is the document, when it was entered into, by and between, how they are called as. Now, let us assume that it is it is entered into between Mr. Srinivas and Mr. Umesh. So, you say that this deed of mortgage is entered into on this, the 5th day of January 2021, by and between Mr. Srinivas, son of so and so, because already I have told you that whenever you are mentioning the properties, you will have to clearly mention the properties. There should be a full description of the parties to the contracts. Full description means very easy to identify that particular person. So, how do you identify that particular person? You specify that he is the son of, daughter of, wife of, etc. And you also specify what is his age and where he is residing at. So, here you say this deed of mortgage is entered into on the 5th day of January 2021, by and between Mr. Srinivas, son of so and so, aged about 40-45 years, and then residing at, of course, when you are writing, you cannot say 40-45 years, because you will have to be very clear. You will have to mention that it is either 40 or 45. So, you mention that aged about 40 years, residing at so and so address, hereinafter called as. Now, the person who is mortgaging the property, we call him as a mortgager, and the person to whom the property is mortgaged is called as a mortgagee. Just like the person who lets out the property is called as a lessor, and the person to whom the property is let out is called as a lessee. Here we call it as a mortgager and the mortgagee. That is, the person who is taking the loan is called as a mortgager, and the person who is giving the loan is called as a mortgagee. So, it is between the mortgager, hereinafter referred to as a mortgager, or the first party, whatever you want, you can mention that, and which term shall include his legal heirs, successors, blah blah blah, etc. By. So, you have mentioned the first party. Now, who is the second party? Let us assume that it is State Bank of India. State Bank of India, which branch? Some branch. Let us assume that it is Jayanagar branch, Bangalore, having the registered office at so and so. Now, since it is not an individual person, it is some company or else some bank. So, naturally, it should be represented by somebody else. So, being represented by Mr. Let us assume it is Mr. Rajesh, who is the branch manager of so and so bank. Unless otherwise expressly mentioned, it should also include the legal representatives of that particular branch, who shall be called as, or which shall be called as the mortgagee, or else the second party, or mortgagee of the second part. So, if you are mentioning mortgager and mortgagee, or first party and second party, it is always preferable that you maintain first party and second party throughout the document, or you maintain that mortgager and mortgagee throughout the document. Now, what is the purpose of mortgage? Very simple. You take a loan, you want a loan, and nobody is going to give you loan for free or without any security. So the mortgagor, the person who is actually giving you a loan, is going to ask you for some sort of security. So you are giving your immovable property as a security for the repayment of a loan. That is, you say that in case I do not repay the loan, then you can always take this property, sell the property, and if in case any advance is there, you can any surplus is there, you can give back that surplus to me. So that is the purpose for which you are entering into a mortgage. Now you say, now for a person to mortgage the property, naturally you should be the owner of the property. If he is not the owner of the property, he cannot mortgage, because I cannot mortgage somebody else's property. So it should be my property, only after that I can mortgage the property. So we have seen the mortgage deed is entered into on so and so date by and between so and so parties, referred to as the mortgager and the mortgagee. Now naturally the bank people will not come to me, I will be going to the bank. So here say the mortgager wanted some sort of loan, whereas the mortgager or the first party wanted a loan of rupees 1 crore rupees. So he approached the second party happens to be the State Bank of India, and the second party agreed to sanction him a loan of rupees 1 crore on the below mentioned terms and conditions. That is, if you satisfy the following mentioned terms and conditions, we are ready to give you a loan of rupees 1 crore, 2 crores, whatever it is. Now what are the terms and conditions then? Then you say that whereas this mortgage deed shall have the following terms and conditions. Now what are those terms and conditions? Point number one is, you will create a simple mortgage, or else you will create a mortgage, that is an encumbrance on the property of the that is on the property on which you are creating a charge. Point number two, that you will that the lessee will give you 1 crore rupees upon the execution of the mortgage deed or upon the execution of the mortgage agreement in favor of the mortgagee. Point number three, naturally once you have taken the loan, you will have to pay them the EMI or else some sort of interest. So you say that you will pay monthly interest of let us assume some 25,000 rupees every month on or before 5th of every month. Point number four, you have to pay the interest. Point number four, once you have mortgaged the property, again you cannot go to some other bank and then say that I will create one more mortgage on the same property, then go to the third bank and then create one more mortgage. That is not possible. That is, creating a second charge is not possible unless you obtain the written consent of the first charge holder. So there you mention that the mortgager hereby agrees that he shall not create any encumbrance or second charge on the property unless a written consent is obtained from the mortgagee. Only after obtaining the written consent you can mortgage the property again to some other charge holder or else to some other bank. So this you can write. Now after you have cleared all the loan, now let us assume you have taken some 5 years period or some 10 years to repay the loan. You can always say that every month I will be paying so much as the easy monthly installment, and upon the completion of my 120th easy monthly installment, my loan amount would get satisfied. Now once that loan amount is satisfied, now what the mortgagee is supposed to do, is supposed to release the mortgaged property. So there you can mention, once the amount has been cleared, then the mortgagee will give me a release deed, or else he will draft a release deed and then he will execute a release deed in favor of the mortgager. Now very important, again, what is the important thing? What is the property that you are actually mortgaging? So you will have to mention the schedule. Schedule what? There you say all that piece and parcel of property number so and so, situated at so and so area, cross area, state, city, state, all those things you mention. And then what is the size of the property, like measuring 30 by 40. If it happens to be an industrial property, you say industrial property measuring 100 by 120, and then bounded on the east, north, west, south. So it is very clearly giving you where the property is actually situated. So you say bounded on the north, south, east, west, so and so property is there. So naturally it means that this is the property. So there is no confusion as such as the property that is being mortgaged is concerned. Naturally, simply you cannot write and then it will have to be signed by the parties to the agreement. Now who has to sign it? It has to be signed by the mortgager and then it has to be signed by the mortgagee. Now let us assume mortgager is an individual, the mortgagee happens to be a company. So if the mortgagee happens to be, or the mortgage, let us assume that the mortgager is a company and the mortgagee happens to be the bank. So if the company is signing it, I mean if the agreement has been entered into by the company, naturally the company cannot come and sign the document. So it has to be signed by one of the directors or the managing director or else a company secretary if they have a company secretary. So naturally you cannot merely put a signature on the document, you will have to affix the for seal. Now why for seal is required? It means that you are signing the document for and on behalf of the company. Similarly, when the bank manager is signing, even he cannot simply put a signature, he will have to affix the for seal of the bank, and then it means that he is signing it on behalf of the bank. So if you do not put the for seal, it means that in your individual capacity you are entering into a contract with which is legally not viable, because you cannot enter into an agreement unless you are authorized on behalf of a company, unless you are authorized by the company or unless you are authorized by the banker. So, what is very important is you will have to enter into the contract for and on behalf of the company. If you are entering it on behalf of the company, then you put the for sale. So, the mortgager will put a signature, mortgagee will put a signature, and of course, if you want, you can also affix the signature of the witnesses. So, once you are able to write all these things, so very important is brainstorming is very important. So, you will have to understand why you are entering into that particular document. So, what is a mortgage? You will have to understand. So, mortgage, you cannot say that I am entering into a mortgage deed with respect to a movable property. You cannot say I will hereby enter into a mortgage deed for creating a charge on my vehicle. So, whenever the term vehicle is there, you do not use the term mortgage, we use the term hypothecation. So, it is hypothecation of the vehicle, it is mortgage of some immovable property, and if it happens to be a fixed deposit certificate, then you do not use the term hypothecation nor you use the term mortgage, you use the term pledge. So, pledge is used with, normally it is used with movable property, and mortgage is used with the immovable property. So, when we say mortgage, first thing that you will have to understand is naturally it happens to be an immovable property. What is the purpose of mortgage deed? That is, you want a loan, somebody else is ready to give you a loan, so you enter into a mortgage deed. Now, what is that mortgage? Why you need to enter into a mortgage? Because nobody is going to believe you and give you the amount, so you are creating some sort of security or charge on the property of the company or on the immovable property. Based on that, the person is ready to give you a loan. Once you take the loan, you will have to give it back with interest. So, when you have to pay the interest monthly, quarterly, half yearly, yearly, whatever it is, and after a particular period of time, maybe 11, maybe 2 years, 3 years, 5 years, 10 years, you will have to repay back the loan. And once the amount has been repaid in full along with interest, the mortgagee will have to release the property. So, naturally, all these terms and conditions will have to be reduced into writing, because you cannot like neither the mortgager can trust the mortgagee, nor the mortgagee is going to trust the mortgager. And if at all there is a dispute, naturally when you go to the court of law, they are not going to trust either of us, so they will go only by the document. So, why a document is required? Because in case of any dispute, it is only the document that can be trusted, and based on that a decision can be given by the judiciary. For this purpose, it is required that you execute or else you draft a mortgage deed in accordance with the requirement of both the parties, and then it has to be signed by both the parties, and there ends the mortgage deed. Once you are able to do this, then you can say that you are reasonably good with the drafting of it. Could be a mortgage deed or else a sale deed or else a lease deed. If you want to learn more about the subject drafting, pleading and appearances, kindly fill the Google form given in the description box below. If you have got any comments or questions, kindly leave it in the comment section below. For more courses from Ekcel Academy, kindly visit excelacademy.com.